I want to bring in Sammy Gyamfi, who just joined us. He's a lawyer, but also the National Communications Officer of the NDC. He was there when John Mahama made his point about how he plans to tackle this through constitutional review. Sammy, thanks for joining us. We have with me here the spokesperson for the GBA. The GBA's position is very clear on the matter. They believe the the procedure adopted by the CJ is irregular, but they are in support of increasing the numbers at the Supreme Court, but maybe not now. Tell me, on the first subject of the procedure, yes, last week your party addressed a news conference. The General Secretary was very clear on the subject and actually put out quite exclusive details about what happened at the Judicial Council. The GBA spokesperson has confirmed all that for us already. Where do you stand tonight on the back of the detailed document that we've now seen from the Jubilee House, altered by the Attorney General, which includes the position of the Chief Justice, detailing the reason why this is needed, with facts that suggest, for example, the things that struck me is that in the year 2022, 2023, where you have the most backlog cases of 595, it's also the year you have the least number of judges. And she says that's why you need more judges. Does that convince you?
Well, first of all, let me commend your guest, who I think have already done justice to the issues. And I'm not going to belabor the point at all, because on the issues of procedure, they have succinctly explained why the approach adopted by the Chief Justice is totally irregular, and I will add unconstitutional, because there is a clear procedure laid out in the Constitution for the appointment of justices of the superior courts. That is what precedents since the inception of this fourth Republican Constitution have used in the appointment of justices to the superior courts. No Chief Justice in the history of Ghana has done what Justice Gertrude Tokuno has done. So what she has done is totally wrong. It was totally uncalled for. It is unconstitutional, and I think she must eat humble pie, concede this fact, and make amends. But beyond the procedural flaws, for me, is the whole agenda and intention, behind the action of the Chief Justice. Because if the Chief Justice was just making a proposal or a request to the President to increase the number of justices of the Supreme Court so as to ensure the speedy determination of matters pending before the courts, then the issue of procedural, lapses or flaws could have sufficed. But here is a Chief Justice going beyond a request to the President for him to increase the number of justices of the Supreme Court, which in itself is wrong. But she actually goes beyond that to propose specific justices of her choosing that she thinks the President should appoint. That, for me, borders on intent. It borders on the agenda. It shows that this Chief Justice is just not interested in having more justices of the Supreme Court, but that she has her own preferred, friends, allies, or people in the judiciary that she thinks should be appointed to the Supreme Court. And that is problematic, because that raises issues of conflict of interest. You understand? Because she is a chairperson of the Judicial Council, which is supposed to advise the President on nominations or the appointments the President makes under Article 1442. And here she is actually telling the President who and who to appoint on the basis of her own self-serving criteria. That should tell you clearly that the main motivation for the Chief Justice is not what we are being told. The main motivation of the Chief Justice is not to have more justices of the Supreme Court for the speedy determination of matters before the Supreme Court, but to have the preferences, the preferred choices of this Chief Justice appointed onto the Supreme Court. And that is why, for me, I think this is reason enough for this Chief Justice to resign.
But